The story begins in Sacramento in the spring of 1979, when the routine rhythms of a young city were interrupted by fear. The region's neighborhoods, with their leafy streets and modest bungalows, were places where working families went about their lives largely unnoticed by the outside world. Yet in April of that year, a crime so cruel, so intimate, and so devastating unfolded that it would haunt a family for decades, baffle detectives across an entire generation, and sit unanswered at the center of a cold case file until science finally found a voice strong enough to speak for the dead. Her name was Eva Chu. She was 29 years old, 7 months pregnant, and loved. She had a life in motion, the gentle routines and hopes of a woman preparing to welcome a child. What happened to her wasn't a random mystery whispered about by strangers. It was a personal catastrophe that hit a family squarely in the chest and never really let go. The cruelty of it was amplified by time itself, because after the shock and the funeral and the police tape came the long years of waiting years, in which there was no arrest, no trial, and no chance to see justice done. In the days following her murder, Sacramento police worked the case as they always did, canvassing, interviewing, collecting what physical evidence was possible in an era before the 3 letters that would change criminal investigation D, and it held much power at all. There were items, there were samples, there were notes written by careful hands and filed in drawers that would be opened and closed countless times, always with the same hope that something might break the stalemate. The case stayed open, evidence was preserved, detectives transferred in and out of the unit, and the file moved from one desk to another, but they kept the memory of Eva with it. Her family stayed in contact. The face in the framed photo remained the same. The years around it piled up. We do not have to imagine the fear and grief that followed. It's there in the tone of relatives who, even decades later, talk about her as if she has just stepped out of the room and will be back at any moment. It is there in the quiet stubbornness of investigators who refuse to write the word unsolved on the inside of their heads. The truth is that a cold case is really just a case waiting for the right technology, the right comparison, or the right confession. And in Sacramento, evidence from 1979 was carefully stored by a department that understood, perhaps more than most, how quickly criminal science was advancing. Then years passed. The 80s rolled in with their own kinds of violence and their own cases. The 90s brought new tools and new optimism. In labs across the country, forensic DNA analysis moved from theory to practice. Databases were built. Profiles were uploaded. The evidence collected in 1979 didn't change, but what investigators could do with it did. You can picture the moment. A technician in a lab, a machine humming, a set of numbers that once meant nothing now aligning into significance. A comparison is made. A profile is searched against a system that holds the genetic signatures of thousands of offenders. And then, at last, a name is returned. The case that had lived in the quiet space between memory and hope suddenly had a suspect who could be found not out on a street, but already behind walls. By the mid-1990s, the name at the center of this match was a man with a history of violence, Moreno Aguayo. When the match surfaced, he was already in custody for a separate offense, serving a long term at a California state facility following a vicious attack on a former partner. Different accounts describe those earlier crimes with different emphases, but they agree on their essential nature: brutal, personal, and capable of leading a woman near death. And it was while he was in that custody with his DNA file that the 1979 evidence was revisited, and a connection drew itself like a taut line from a Sacramento crime scene to a prison cell. Investigators now had what they had not had for years: a living suspect, a testable theory, and the ability to place a name where only a shadow had stood before. When prosecutors laid out their theory of the case, the narrative was as stark as the science that supported it. They argued that in April 1979, Aguayo abducted and sexually assaulted Eva, then murdered her, ending not only her life, but the life of the child she carried. The language prosecutors used was careful but unflinching. They understood the gravity of alleging a crime that annihilated two futures at once. The case hinged on the strength of preserved evidence and the developing reliability of DNA testing. The defense countered by pointing to the possibility of laboratory error, cross-contamination, or interpretive bias that might have emerged over years of storage and reanalysis. That is what defense lawyers are meant to do. They press on the seams, they ask whether the science is as invulnerable as it seems, and they insist that jurors consider not the advancements of technology, but its known limitations. The jury would, in time, weigh the arguments and the evidence and decide. The courtroom is where timelines transform into verdicts. In the 1990s, Sacramento County presented the evidence collected in 1979 and the DNA conclusions that modern labs had drawn from it. Jurors listened to scientists translate base pairs and probability into English. They listened to detectives who had carried the case like a small stone in the pocket of their careers. They heard about Eva's life and what was taken from it in her case, in the child's case, and in the lives of the people who loved her. And then, after testimony and cross-examination and the long pauses that juries take when they are deciding whether to believe beyond a reasonable doubt, they reach their decision. Joseph Moreno Aguayo was convicted of the murder of 29-year-old, 7 months pregnant Eva Chu. For Sacramento County, this was more than a guilty verdict. It was an answer to a question that had stood for years. For Eva's family, it was a chance to say the word justice and mean it. And when the penalty phase ended, the court imposed the harshest punishment California law allows. In 1996, Aguayo was sentenced to death. What follows a death sentence in California is not an ending so much as a long, institutional afterlife. There are automatic appeals, appointed counsel, supplemental briefs, and the slow machinery of a system designed to minimize the chance of irreversible error. In Aguayo's case, appellate dockets reflect years of post-conviction work, including state habeas proceedings and briefing schedules that continue to this day. The California Supreme Court's minutes have, in recent cycles, granted extensions for supplemental briefing, confirming that decades after the verdict, the case is still alive on paper, even as the man at its center remains confined to a narrow world of concrete and steel. The broader landscape around him has shifted as well. In 2019, California's governor announced a moratorium on executions, which means that even though the state maintains a death row, the machinery of execution is paused. For families, for defendants, and for the public, the word waiting hangs over everything. Some see the moratorium as a humane pause in a system too prone to error. Others see it as a denial of the jury's will in the most aggravated cases. But whether you stand on one side of that debate or the other, it explains why cases like Aguayo's can exist in a strange tension, legally final in many respects, practically suspended in others. The state lists him among those under sentence of death. The courts continue to process filings. The prison continues its routines. The family continues to live with their loss. If this were only a story about legal process, it would be easier to tell. But it is also the story of a young woman whose life was taken and a family that still speaks her name. Over the years, relatives have given interviews, stood at podiums, and allowed themselves to be filmed as they describe the ripples that one act of violence sends through time. You can hear in the tremor of a surviving daughter's voice the way grief ages but never disappears, how the absence of a mother is felt in anniversaries, holidays, and the quiet ordinary moments when a child reaches for a hand that isn't there. The fact that this case was called one of Sacramento's most pursued cold cases is not just a testament to police persistence, it's a testament to a family's endurance. They waited for science to catch up. When it did, They watched as the courtroom finally said what they had known in their bones, that Eva had been wronged and that the person responsible had a name. There is a particular brutality in crimes like this, crimes that involve a pregnant woman whose future includes another life nested within her own. The law can account for that in different ways. Some jurisdictions recognize the unborn child within the charging decisions. Others reflect it through aggravating circumstances at sentencing, but on a human level, the grief is doubled. When prosecutors stood before jurors in Sacramento and described what had been taken, they were not merely talking about the end of one life, but the erasure of two. They were not only describing a crime scene, but a horizon of plans that would never be realized. The gravity of that truth is part of what drove the determination to preserve evidence in 1979, and to retest it years later when the technology matured enough to draw meaning from it. The defense in a cold case DNA prosecution will always ask jurors to confront the limits of certainty. They will argue that storage conditions may have degraded samples that laboratory protocols have changed, that contamination is not a myth, and that when the state's entire case depends on a set of scientific conclusions, the burden is on the state to prove that every link in the chain is unbroken. In Aguayo's trial, those arguments were raised questions about human or machine error, statistical interpretation, and the reliability of results extracted from evidence older than some of the people in the jury box. That is a necessary part of the system's integrity. But in the end, the jurors returned not a compromise, but a clear verdict. They had watched the cross-examination. They had weighed the probabilities and the procedures, and they found that the evidence was enough to convict beyond a reasonable doubt. When we talk about the long arc of a case like this, we also talk about what it means for a community, for detectives who worked Eva's case in the early days of their careers. The 1990s arrest was a vindication of habits that can feel thankless. Meticulous note-taking, careful packaging, and an almost superstitious refusal to discard anything that might someday matter. For prosecutors, it was a demonstration that science can revive the voices of the dead. For defense counsel, it was a reminder that the right to test the state as claims does not expire just because the case is old. And for the public, it was a lesson in patience. Justice delayed is not always justice denied, but the delay leaves marks on families, on communities, and on the people who have to live in the long middle between crime and conviction. Today, Joseph Moreno Aguayo remains listed among California's condemned, his name appearing in projects that catalog the men and women sentenced to die but still alive under the state's moratorium. His case continues to surface in the California Supreme Court's minutes, where brief lines confirm the status of filings and extensions that, to the uninitiated, might look like bureaucratic trivia, but to the trained eye show a case still moving, however slowly. Meanwhile, Eva's story stays in circulation not only through official records, but through the mouths of those who loved her, and through the retellings that seek to keep memory from being buried under procedure. There is an image that stays with you, a stack of boxes on a metal shelf in a police property room. Inside, a sealed envelope contains a swab, a fragment of fabric, a sample labeled in a hand that belonged to a detective who has long since retired. The boxes are a kind of time capsule, and what they hold is not just evidence but possibility. When scientists in the 1990s loaded Eva's case materials into instruments capable of detecting and amplifying what earlier machines could not, they were, in a sense, opening a message from the past. The message said, "This is what happened." It said, "Here is a name." It gave a family something solid to lean against after years of standing on air. But even with a conviction and a sentence, the system does not allow itself to move quickly to an irreversible act. That is by design. Capital cases are built to move at the pace of precision, and that pace is often measured in years. If that frustrates a family seeking closure, It is also the structure that has, in other cases, prevented tragic mistakes. In California, the current pause on executions means that the final step is not available to the state, even in cases where jurors have asked for it. For some, that is a moral good. For others, it is a deferred promise. For our purposes, it is a context in which to understand why a 1979 murder, tried in the 1990s, is still not finished in the way the verdict form suggests. The file remains open in the sense that courts remain open. The family remains vigilant because grief has no off switch. And the community remains aware that the line between solved and complete is not always the same. In telling Eva's story, we also recognize the broader trend it represents. Across the United States, cold cases from the 1970s and 1980s have been revived by the thoughtful preservation of evidence and the explosive evolution of forensic genetics. Names have been drawn up from the depths of time. Men thought to have gotten away with terrible things have been summoned into courtrooms by the quiet insistence of a scientific profile. The investigators who saved those swabs were, in effect, saving a chance at truth. In Sacramento, that chance was realized for Eva. The science did not erase the pain, but it did finally answer the question of who. A true crime story like this always ends in two places at once. In one ending, we see a defendant in a high-security unit, his days regimented, his future narrowed by walls, years marked not by seasons, but by filing deadlines. In the other ending, we see a family around a kitchen table, an empty chair that might have held a mother and a child now long grown, the ache of anniversaries, the ritual of remembrance. Justice, when it comes, does not fill the chair, but it does allow the family to say that the law saw what they suffered and that the state took their loss seriously enough to put a name to it and a sentence behind that name. That matters. It matters that the city remembers. It matters that the police took care, that the lab got it right, that the jurors listened. It matters that a young woman who is preparing to welcome a child did not simply vanish into a statistic. And it matters that we can say her name, Eva Chu, with the respect owed to those whose stories were cut short by someone else's violence. The case of Joseph Moreno Aguayo will continue to exist as a set of docket entries and filings for some time yet. But the center of it, the reason any of this was done, is a life that should have continued, and a child who should have been born. When you strip away the years and the acronyms and the sterile language of appellate minutes, that is what remains. A family's love, a city's persistence, and the stubborn, undeniable truth drawn from a strand of DNA that the past left behind for the present to finally read.